Susie, can we talk a little bit about, adult children have inherited a house, mom passed away, dad passed away, perhaps 10, 15 years ago, and they think, the process is going to be very straightforward. What would you advise them to consider in a scenario like that?
So one of the things that we often run into is maybe if one of the parents passed away some time ago and there was never a probate opened and maybe the surviving spouse never went to see an attorney just to make sure everything passed the way it needed to, is sometimes, especially with older deeds, mom and dad may have been listed on there with just their names, Bob and Mary Jones, but there was no other designation. And in Colorado, if it's listed like that, the default is that mom and dad own the property as tenants in common, which means they each owned 50% of the property, but upon dad's death, for example, if he died first, his share did not automatically pass to mom, but everyone has just assumed that happened. And now, years later, when mom passes and the family is trying to sell the home and they suddenly realize, oh my gosh, mom didn't in fact own 100% of the home, that you might end up having to go back to open probate for dad to pass that interest to mom's estate so that mom's estate can then pass it to, can transfer the property to someone else. So it's one of those sort of hidden, landmines that people sometimes don't know about until years down the road. So I would say one of the things people could do is just if, say one parent passes, probably a good idea to go see a probate attorney and have them check the deed on the home just so it's really clear what happens next.